And may it please the court. Attorney Adam Gurley on behalf of the appellant, the Grand Reserve Condominiums Association at Tampa, Incorporated. I'd like to reserve 5 minutes of my time, if I may, Your Honor. Thank you. Unless the court has a particular issue that you'd like me to start with, I'll go through what I've prepared for the court in response to.
So I want to know when you believe the time period, the reasonable time period during which a holder of right of first refusal has in which to exercise that right begins to run.
So it begins to run. They have the right of first refusal for as long as the contract is in existence. So until the contract is terminated. Now we've seen contracts, and in fact, one of the cases.
When is in other words, the holder has the right, conceptually speaking, but when does the right of first refusal as it pertains to a particular offer arise? And when does that time period that you're contending that it was exceeded, meaning they didn't exercise their right within a reasonable time, when did that time period begin to run? As to the specific offer that you're contending, they had no right to refuse.
Absolutely, Your Honor. It began to run, in my view, on May 3rd when the initial communication was sent to commercial laundries that said, we are terminating the contract. Here's the 30-day notice under the contract. So contract with the right of first refusal terminates in 30 days. And that same communication said in 2 separate places, we are moving forward with a different laundry service provider. That is the communication.
How does a holder of right of first refusal know what terms to match?
Your Honor, and that's addressed in some of the cases both that I've cited and in counsel cited, including the Blind Monk versus USO 4th DCA case. And it says, we see some contracts, including in the Monk case, where it says that where the party receives an offer, they have 7 days upon receipt of that offer to convey the terms to the other side. So typically that's controlled by contract. A well-drafted contract will spell out how that is to take place. Here, where we have no such provision that requires disclosure of those terms up front, it's the acknowledgement, it's sending the notice of termination that says we have a new contract, and then the burden is on commercial laundries.
It says we have a new contract.
It says we have a new.
You said 2 things. You just said we're moving forward with another provider, and we have a new contract. Can you show me where in that communication it says either of those 2 things?
I can, Your Honor, and I'll quote.
Why don't you just quote me the communication?
Absolutely, Your Honor.
Convey and to a holder of right of first refusal that there was an offer that they could at that time manage.
Certainly, Your Honor, and this is the May 3rd, 2022 letter that was sent. It says, at the time, we have made the decision to change our laundry service provider. It goes on to say, and I quote,
to change our laundry service provider.
To change our laundry service provider, but it goes on, Your Honor. It says in the following paragraph, please allow this letter to serve as our 30-day notice of cancellation as per our service agreement, as we will be starting our new laundry service provider on June 7th, 2022. To me, that is express representation to the other side that we've retained a new laundry provider.
That's not what it says.
It says they have a start date.
They have a start date, maybe they're putting it out to bid with that start date. I mean, it doesn't say we have a contract. Let's say we have a proposed contract with a new provider. We said we're going to start with a new provider, whatever that was. Correct?
That's correct, Your Honor. And I believe that
And I can understand what the implication is, but it's not really what it said.
But I do think it triggers commercial laundry's obligation to say we are interested in exercising our right of first refusal. They're on notice that we have a new laundry provider starting as of a certain date. You're right, it doesn't expressly say we've entered into a contract.
Okay, so we're on notice that we have a new laundry provider. Or is it, does that notify the holder of right of first refusal that there's a specific laundry provider who's made an argument, made an offer?
It does not let them know that there's a contract in place, Judge. I think,
an offer to lease.
Judge, I think with the exact start date of the new provider, that I think it can be reasonably inferred, if not, fairly clear that they've retained a new laundry service provider right down to the start date. June 7th, 2022, this new provider is coming onto the property with their equipment. I think that's pretty clear that they've retained a new laundry service provider. I understand what the court's saying. It doesn't say that expressly, but I think it says it well enough here and triggers commercial laundry's obligation then to come back and say, we'd like to exercise our right of first refusal, that their 30-day clock is triggered. They could have prepared an agreement that said, upon receipt of an offer, or upon entering into a contract, we have to give 7 days notice to commercial laundry. The contract doesn't say that. So I think the obligation that we're inferring the association has from the start to issue the terms of this new agreement, no such obligation exists as a matter of statute or in the terms of the contract. There's no contractual requirement that they disclose those terms on the front end.
Was there ever a response to that letter?
There was a response to that letter. There was not a timely response to that letter, Judge. So it said, we're moving forward. I believe the date was June 7th. It said, this is the May 3rd letter. It says you have 30 days. It's a 30-day termination letter. So the contract with the right of first refusal expires June 3rd, 2022. Commercial Laundries does respond until, I think it was June 15th, 2022.
So that's not timely as to whether that notice is a notice of termination or a notice of right of first refusal.
It's not within 30 days.
Correct.
Within 30 days.
Exactly. They've
So you're saying it expired by operation of law after the 30 days. It doesn't matter what they said.
Exactly, Judge. They had 30 days to respond to that and acknowledge, we would like to exercise our right of first refusal, or as in the Monk case, say, we'd like to know the terms. What are the terms?
And you're saying your client was under no obligation per the lease to provide more detail than saying, we got this offer, we're going to this other outfit. That's all they had to tell them.
Correct, Your
It
Honor.
didn't exactly say that, but
No.
that it implied that.
Correct, Your Honor. Correct. There was no contractual obligation. Exactly. There was no.
Being from New York, you do it like that.
I do it my way, but I understand what you're saying. I just want to make sure.
Yep, absolutely, Your Honor. So there was no contractual requirement that they do that. They gave the appropriate disclosure. And in fact, you'll see in the Monk versus USO 4th DCA case that was cited in the Appellee's brief, it actually, the facts are the side who holds the right comes back to, in this case, my client, and says, what are the terms? It emphasizes the obligation to come back and say, what are the terms? And when that side who was affording the right then failed to disclose the terms and just waited out the clock until the 30 days or whatever it was in that case expired and then said, sorry, bad luck, you missed your opportunity to exercise your right, the court said, well, that's not good faith. And even more so in that particular, what's that?
The point is you don't have that.
Exactly, Judge. We don't have that here. So the obligation was triggered to inquire upon the May 3rd notice. They had 30 days until June 3rd to do it. They didn't inquire. So that is the first basis.
Does that obligation not turn on the reading of that May 3rd letter to essentially be only presented with one interpretation, which is that we have already received an offer from the provider? If there's another interpretation, in other words, if the recipient of that communication could infer that you're shopping around for a new provider, how does that, whatever that reasonable time period can run?
Your Honor, I think it runs as of that notice, and I don't think it's a reasonable standard as far as the
Well,
reason.
that could be read to mean we're going to get a new provider. In other words, does the holder of the right to first refusal say, hey, by the way, if you have one already, or please let us know what the terms are. If you haven't found one, please, we just want you to know that we would like to receive the terms sometime in the future. Or is the sender of that communication permitted to just, keep in the dark about if and when they ever do receive an offer with specific terms?
I believe, Judge, upon the May 3rd letter, it was Commercial Laundry's obligation to inquire. It was not the association's obligation to say, here are the terms, to convey those terms with the letter, that it was Commercial Laundry's obligation to inquire. And again, we see that in the case law that's addressed here in the briefs, where the party who has the right, and this is a fundamental principle of contract law, the party who has the right has the obligation to exercise that right. The burden is on them to follow through and pursue that right. Here, the association, again, gave them the 30-day notice. They could have, Judge, executed a contract and negotiated with consideration for a Commercial Laundry, I apologize, Your Honor, commercial laundry or the association. They could have had a contract that said, association, if you receive terms within 7 days, you have to convey those to the other side. Then the other side has 30 days to respond as to whether or not they're going to agree to that. And that's exactly what the contract says in the Monk case. They didn't contract for that here.
In the Monk case, remind me or inform me, did they have a similar to this other aspect of your case, which is, according to the Appellate, Grand Reserve already had violated by entering into a contract, over a month prior to that May 3rd? In other words, they entertained an offer, accepted the offer, entered into a binding contract fully 1 month before you're contending that they gave notice of the right of first refusal that their right had arisen.
Your Honor,
That's something in the Monk.
That's not in the Monk case. That is the facts in the CSC case. The CSC case, let's see, and that's the 4th District Court case, very similar to the case we have here. It's a right of first refusal under a laundry services agreement. Same here, it runs the full term. It becomes a month-to-month agreement. And the 4th District Court of Appeal in that case finds that the right of first refusal provision terminates upon the expiration of the contract. And in that case, we do have the fact pattern.
In CSC,
Did you have a letter? I mean, in your case, you also have a letter from the association's counsel, June 28th.
Correct, the subsequent.
So here's the contract terms. Please, the association demands that you respond in writing whether your client shall be exercising its right of first refusal within 7 days of the date of this letter. What does that mean?
Yeah.
It had already expired.
It had already expired, Your Honor, not the most artful language, not language that,
was it more accurate?
Seemed fairly intentional.
I don't disagree, Your Honor.
Demand that you respond in writing. It's not like an accidental,
Sure, and it says confirm that you'll be exercising your right of first refusal. So again, looking.
Should your client refuse to let the premises, they should come and get they must come and get their stuff. I mean, that sounded like the association believed that it was still open because they told them what the terms were.
I agree that they may very well have opened the door.
I mean, just let the judge to rule the way he ruled.
Absolutely. I think that's where the trial judge had trouble with this case from an equitable standpoint. But the legal issue there, and again, while that letter is not particularly artfully drafted or how I would like it to have been drafted as I stand before.
Like to let it out altogether.
Yes, I would like that letter to not exist.
We're going to be consistent with your argument. It should have said go pound sand.
Exactly.
Yeah, exactly.
That would have been my preferred language of that letter. But I've inherited what I've inherited. But nonetheless, I will still represent to the court that the contract, the underlying 2011 contract with the right of first refusal expired on June 3rd, 2022. On its own face, as a matter of contract law, it expired as of that date, as did the right of first refusal.
Let me ask you this. Would it have expired, let's say, there was no May 3rd letter, and during the term of the contract, the month-to-month contract, the association had entered into a contract with another provider, not provided whatsoever that he could conceivably be considered notice of the right of first refusal. Where would it be?
Without that May 3rd letter, without the 30-day notice of termination letter, we don't have a terminated contract, and therefore the right of first refusal likewise lives on.
What if the May 3rd letter had not mentioned to be provided? What if they just said, the May 3rd letter is a termination of the contract? You're saying it was also notification of an offer that triggered the right of first refusal. But what it is, what if it had not mentioned anything that even could remotely be conceived of as a notification of an offer that the holder the right of first refusal to refuse? Then, and that the fact's the same, they already entered a contract with the provider. You're saying that someone holds the right of first refusal is out of luck because time ran out, we didn't tell you.
Well, I do think that, Your Honor, if those were the facts, because I do think that is where we allow parties to contract amongst themselves. Sophisticated.
So this contract meant you have a right of first refusal, but we don't have to tell you ever about any offer received.
Well, when you're terminating,
We can, in the dark of night, enter into a contract with a party, and even though you had the right to refuse that offer, we can keep you in the dark. That's what the parties contracted to do.
well, I don't think there's any contractual obligation for the association to disclose up front. I think under the case law, it is commercial laundries, in this case, burden to write back to that letter and say, we acknowledge receipt. We want to exercise our right of first refusal, send terms, to the extent that you're engaging someone else. But of course,
You're done here, 5-minute rebuttal time, use them as you please.
thank you very much, Judge Northcutt. So just to finish that point, but we have much better facts here. We have what I think is very express language that that we're starting on June 7th. And then even with the June 20th letter that, again, I'd like to not have that exist, the prior contract had already terminated. So the only way that new letter comes into play once we have a contract that's terminated is if that new letter, which is now more recently on appeal, this argument's been put forward by opposing counsel, that new letter is somehow a new agreement or a new contract. Well, that's not been pled here. The trial court certainly didn't find that that's a new binding offer that was accepted and a new contract. And that was not pled in the complaint. The complaint's very express. It's alleging a breach of the underlying 2011 lawsuit and that right of first refusal contained in that provision. So that June 20th letter, while again, not great facts, the appearance of it isn't ideal. Contract law still applies. The initial contract had been terminated for over 2 weeks prior to the time that letter was sent. And again, without any statutory or contractual obligation to convey terms, without commercial laundry exercising, it's their right, it's their burden to exercise their right and pursue that right and to inquire upon receipt of that notice. When we say we have a laundry service provider starting on this exact date, I think it's logical and makes sense to say, okay, now they write back and say, what are those terms we'd like to match them? They know we're moving forward with a new provider. They know the start date. I think that's certainly enough to the extent that there was any obligation to disclose that. I think the association filled that obligation here. So with that, I'll reserve the remainder of my time. Thank you.
You've got 3.5 minutes.
Thank you, Judge.
Police Court, my name is Walter Smith. Excuse me, I represent commercial laundries. I think the basic flaw in the argument here is that the holder of the right of first refusal has some obligation to come up forward when they get a lease termination letter and that they have an affirmative obligation. There is no such obligation. And another flaw is this 30-day thing. There isn't any such 30-day provision. I think what we need to do is start with the lease itself, and that's what distinguishes this case from the other cases that were cited. In this particular case, if we start with the lease, you find that number one, the right of first refusal doesn't start until the expiration of the lease term. All of these cases they cited have very specific expiration dates that weren't complied with. Each one of those, CSC, Douglas, and the Gower case, all of them have a specific term stated in the lease of when this option had to be exercised, and in none of those cases was it, and the court so found. There were various variations on that. For example, there were discussions after the time expired. Did that restart the period? No. But in every one of those cases, there was a specific term, and the term wasn't met. So basically, you've got to, and what it goes on to say then is upon the expiration of the lease term, now the commercial laundries has a right of first refusal to meet any bona fide offer to let said premises on the identical terms and conditions of said offer. So we've got now two cases that come into play. Steinberg saying that in the absence of specifics, which we had in all the cases they cited, but which we don't have here, Steinberg says it's got to be reasonable. That's a common sense, reasonable man approach. It's got to be reasonable. There is no 30 days. Steinberg, Monk, nothing says 30 days. It's a reasonable period under the factual circumstance. And then, of course, the Monk case also takes a common sense approach of how can you conceivably exercise a right of first refusal, which has to be on the identical terms and conditions. How can you exercise your right of first refusal on identical terms and conditions unless and until you know what that offer is? Now, if we look here, again, on September 7th, a new lease was entered, excuse me, on March 3rd, March of 22, a new lease was entered into with TLC. Our lease was an exclusive right to operate the laundry facility. The lease they entered into in March gave TLC the exclusive right to operate laundry facility. Our lease was breached at that time. Game over, basically. There was no way that Grand Reserve could give us a right of first refusal because they'd already entered into a contract.
There are cases in which, get recorded opinions in which, leases have been, set aside. I mean, that's often the upshot of a breach, right?
Well, sure.
So.
But you obviously can't say that you were proceeding in good faith somehow, and that had we come forward, you would have gotten out of that lease somehow. If that was the case, we'd be here today, and I'd be arguing on behalf of TLC because their lease had been breached. So, I mean, it's just, the lease was breached, and at that point, game over. But putting that aside.
Well, the remedy would be breaching specific performance. You'd exercise the option.
Our remedy would have been to sue for, well, we couldn't get specific performance because there'd be the rights of an innocent third party involved. TLC's rights, the court, I don't think, could give specific performance. Our remedy, I think, would be damages. But the fact is.
Well, we don't know that they were innocent.
Well, we don't know. That's true. But I mean, assuming for best case, we assume they were. But under any circumstances, if you look at this, the May 3rd letter, and that's very telling too, that their position is, the appellant's position is that somehow that should have, that created some affirmative burden for us to come forward and say, don't forget about our right of first refusal or whatever. Again, there's not a single case that puts the affirmative obligation on the holder of the right. The obligation is on the person who has the duty to come forward with a proposed agreement, say, do you want to meet these identical price and terms or not? That's how you satisfy that. And of course, they did that well after the horse was out of the barn. But that letter doesn't do, in my opinion, that letter does two things. It says, we're canceling your lease, which they had every right to do. And at that time, upon the cancellation of the lease, that's when our right of first refusal is going to kick in. And it also says we're going to change vendors. Now, they're suggesting that saying we were going to change vendors, again, created some burden. It doesn't. So what happens then is the lease terminates under the notice, the lease terminates on June 3rd. So June 3rd is when our right of first refusal arose, upon termination of the lease. The lease was terminated June 3rd. That's when our right of first refusal arose. And of course, keep in mind.
Why is that your right of first refusal?
Well, because on May 3rd, they said we're terminating the lease in 30 days. And under the terms of the lease, they could terminate it on 30 days notice. But the May 3rd letter, the purpose of that letter was to terminate the lease effective June 3rd.
Okay, so your right of first refusal to refuse what?
Our right of first refusal commenced on June 3rd, the expiration of the lease. If you look at the lease, it says upon expiration of the lease, we have a right of first refusal, identical price and terms. So the lease terminated June 3rd. That's when our right of first refusal arose. Now, you can't meaningfully exercise it until you know the price and terms. That's what Monk says. So on the
Where does it say upon termination, we have a right of first refusal?
well, I'm sorry?
You said upon it, that the lease says upon termination. we have a right of
The right of first refusal, the right of first refusal doesn't arise until the prior lease terminates. So what happens then, we don't even find out there's another lease, and then until now, the May 3rd termination letter doesn't say anything about a new contract. On June 7th, that's the first time they ever say,
So if you, let me back up for a second. So if during the term of the lease, prior to June 3rd, commercial laundry had been presented with an offer that it had right to refuse, that would not trigger the right of first refusal?
oh, sure, no, I think it did, but
You're saying that the termination of the lease, of its lease, the right doesn't arise until June 3rd?
well, no, I'm not saying the right doesn't arise. I'm saying,
You're saying that, are you saying that it arises at the earliest of June 3rd?
no, but the right, if you're looking at when, these other cases have a specific date, 1 year or whatever.
Okay, so we're talking about two different things. Okay, the 1 year, these other cases, 1 year means that the right was persisted 1 year after termination.
Right.
Okay, that's the two, I guess we're defining our terms. The right of first refusal in general, meaning the right to refuse any offer that may be received, in those other cases, persisted for a year after the lease by operation of the terms of the lease. What I'm asking is, when did the right to refuse this specific offer arise? You're saying that's June 3rd?
The right to, we couldn't accept this offer until we were told about the
That's
terms.
when the right to
Start.
refuse the specific offer from TLC arose.
Yeah, and that's what I'm trying to show you, that chronology is on the June, we didn't even know there was a new lease in effect until June 7th.
Right. So you're
And-
saying that, so you're not, but you're saying, you're saying, are you saying it's June 3rd or June 7th?
Well-
The right to refuse the offer made by TLC, which obviously is already.
I don't even think it's yet, because on June 7th, they say there's a new lease,
Getting that.
but we still don't have the terms.
I understand.
So then on June 15th, we find out that now we know there's another lease. So I write them and say, hey, we have a right of first refusal. Send us the lease. What are the terms of this new lease? We want the opportunity to consider whether or not we want to exercise our right of first refusal. They didn't provide that until they provided that on June 20th. So June 20th was the first time we ever saw a copy of the lease, ever knew its terms, ever had a meaningful opportunity to respond to it. That's June 20th. And in that letter, they lay out the terms. Okay, you got it. We acknowledge it. We're going to give you, here's the lease. We're going to give you 7 days to accept, and it's got to be on the exact same terms and conditions. And if you don't do it, you better get your stuff out of there right away.
The third party involved that leased that space, they're innocent of any wrongdoing, correct?
I'm assuming that.
Okay, I mean, so no one said they didn't act in good faith. So my question becomes, is this a matter of a breach of a lease where the remedy is argued, where maybe you don't get the right of first refusal, but you do get the right to seek damages for them breaching the lease?
Right, well, we had, and again, I don't think you could effectively give specific performance if a third party was.
They gave you the notice, or they gave your client the notice within of 30 days that the lease is going to terminate. What triggered in your client's mind at that point? Oh, I don't want to terminate, I want to negotiate, I want an extension, or they just let it lapse on its own weight?
We can't do anything until they could have terminated the lease and not gone into business with anybody else. That's fine, no problem.
So in other words, you want the landlord to have a vacant place there? I'm not sure what the argument is.
No, the argument is very simple. We have a right of, if you want to terminate the laundry facility, you want to put hookups in the individual apartments and not have a common laundry room anymore, you're free to do that. That's what the intent of the parties was in the contract, terminated upon 30 days notice. But if you're considering getting another laundry company in there, you got to tell us, give us the proposal, and give us an opportunity to meet those price and terms. And that was part of the original negotiated deal. And so then they acknowledge that, they give us the contract, they say, okay, you got 7 days to accept it. And 2 days later, I respond and say, we accept identical price and terms. I mean, we carried out our part of the contract. This was, to give you the bigger picture, this was a 2-count complaint, and the second count was against TLC, and we alleged tortious interference of, so, we can assume for purposes of today, they were in good faith, but certainly that's not what the facts were. But, so based on that scenario, you've got 2 cases that come into play. One is Steinberg, and says you have a reasonable time after you've given a legitimate opportunity to consider the price and terms and accept them. So that was 2 days. And then, of course, Monk plays into that, and Monk's the one that says your time doesn't start, what's a reasonable time doesn't start until you're given the contract or given the price and terms, because you can't meaningfully accept. And I think it was the Monk case where they said they had an owner had a right of first refusal, and they said, well, we're going to sell, and are you interested? And he said, I'm interested, and give me some more material. And then they later ignored that right of first refusal. They didn't follow up with him, but they said, oh, that we gave him an opportunity. We told him we were going to sell it to somebody else, and that if he wanted to exercise his right of first refusal. The Monk case clearly shows there's no affirmative obligation on the hold of the option. The Monk case clearly shows that the obligation is on the person that owes the duty to come forward. And the Monk case clearly says that time doesn't start until you know the exact terms and conditions, and can make a meaningful determination whether you can say, yes, I'll meet those or not. And it all makes common sense. And if you step back, any other argument doesn't make it doesn't meet the common sense test. It doesn't say, well, we entered into this other deal, but we told you after the fact, and we could have gotten out of the other deal. I mean, none of that stuff makes sense. The only thing that makes sense in a commercial setting is to structure it the way this was structured, and interpret it in a way that Steinberg and Monk interpreted. So I'll leave it at that unless you have other questions. Thank you.
Thank you very much.
Your argument regarding the May 3rd letter rests on the premise that the recipient, over the right of first refusal, must have presumed the possibility that your client had already breached the contract? No, I'll tell you why I asked that question. Because the right of first refusal is a right to meet a bona fide offer. So if the recipient of, the holder of that right receives a communication that says, we've made decisions to change our laundry service and we'll be starting a new laundry with a new provider on a certain day, in order for them to reach a conclusion, they must have reached, they must have presumed that Grand Reserve had already breached their right of first refusal provision. Because they're supposed to have the right to refuse an offer.
Exactly, Judge, and that's the distinction I would make. So I don't think that they have to presume that we've entered into a contract or that we've already breached. I don't think entering into another contract is technically a breach, but they don't have to assume that we've entered into another contract. They only have to assume that we've received an offer with terms. And I think a May 3rd letter that says our new service provider is starting on June 7th, 2022 is absolutely sufficient to say we've received an offer with some terms. In fact, we're moving forward with those terms.
So, but are you suggesting that as a matter of law that's the case, or are you suggesting that that's a matter of fact? And if it's a matter of fact, aren't we bound by Judge Wolf's finding that the later communication was the first notice that they had?
Judge, I think it's a matter of law that we sent a 30-day notice of termination provision, and where there's no dispute that that's the applicable provision to terminate the agreement. And I think the matter of law is that the right of first refusal expires on the date that the contract is terminated.
That's a talk about when the right in the abstract expires. I thought, Judge Northgate, speaker himself might be presumably thinking, but the question about when the right to refuse the specific offer arose. And you're saying it arose on May 3rd when your client sent a vaguely worded letter terminating the lease and suggesting that the new service provider would be coming on board on June 7th.
I do think that's the operative date, Judge. I do think June 3rd was the end of their time frame to inquire as to the terms of
but if the recipient letter is presuming that that Grand Reserve is going to operate in good faith, then the recipient letter is presuming that they would be notified that an offer from a specific provider had been made.
And Judge, and what they could have done,
Not a contract, but an offer.
and again, I think that the representation in the letter would have let them know we have an offer. And the question as to what they could have done or what they should have done, what their obligation was or what their right was, we saw it play out. We saw it play out just untimely. What they should have done is exactly what they did. They should have just done it earlier, because what they did, Judge, is they eventually responded and sent a letter, whatever, 12 days too late, and said, tell me what the terms were of your new bona fide offer. Send us those terms. They didn't write back and say, we want to move forward. We want to move forward. We don't have the terms. They did exactly what their obligation was within the 30 days. They responded and said, okay, what are the terms with your new laundry care provider? So our letter not only, in my view, was sufficient to tip them off, we have a record that shows that it did tip them off. They did write back, Judge, and say,
I thought the record shows that the tip-off came when they said, remove your equipment. We're still going to have, we got this new provider. Counsel's brought up the hypothetical, which is completely consistent with the agreement, that Grand Reserve could be deciding not to, ultimately decided not to go with laundry service altogether, right?
mm-hmm.
And so their argument is, you may not think it's credible or persuasive, but you argue against it, is we didn't know that there was actually another actual provider who had made an offer, much less that they had entered into a contract, until you said, hey, get your equipment out because we got these new guys. And that's when our right of first refusal as to the specific offer arose.
And so they could have arranged for a contract that addressed that, just as the Monk case did, just as the CSC case did, the contract in that case that said the right of first refusal will survive for 1 year. Or in the Monk case, the right of first refusal.
You're jumping topics here. You're jumping a topic, you're going to the topic of when the right in the abstract expires. But their right to refuse a specific offer arose arguably when your client entered into a contract with another provider, well before the end. What I want to know is what I'm talking about is when their right to refuse this specific offer arose.
Judge, again, I think it was May 3rd, 2022, when we let them know we're moving forward with another provider.
Okay, so you're at the end of your time.
Okay.
You and Judge Atkinson.
Thank you very much, Your Honors. Appreciate your time.
We'll be in recess for 10 minutes.
All rise.